State of Michigan versus Jessica Flores, 26-00364. Parents, please.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Good morning, Your Honor. Attorney Derek Etheridge from the Office of the Public Defender on behalf of Ms. Flores, who is appearing by video.
Okay, Ms. Flores, probable cause conference today for child abuse third. There's a preliminary examination March 6th, 8:30. Are we continuing to exam?
We are not, Your Honor. Ms. Flores has accepted a plea offer from the people to plead to an added count 2 of domestic violence with a sentencing agreement that the people have no objection to 7694A status if she is eligible and no further upfront jail at the time of sentencing. Upon successful plea and sentencing, the people will be moving to dismiss count 1. I have a plea sheet that's signed by myself. However, it's not signed by Mr. Etheridge if I approach.
Mr. Etheridge.
Your Honor, that's an accurate depiction of what was discussed for a plea resolution. This is a 93-day domestic violence count. I've discussed it with Ms. Flores in a breakout room, and she advised me that she would accept it at this time.
Ms. Flores, is that accurate?
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
You can put your hand down. Before you can accept the offer and plead guilty, you have to first understand that your rights. First, you have the right to the presumption of innocence. You're innocent until proven guilty, and you can take this matter to trial. You have the right to jury trial, in which you can require the prosecutor first prove each element of the charge being brought against you beyond a reasonable doubt. You understand your rights so far?
Yes.
At the time of trial, you have the right to remain silent and not have silence be used to prove or imply that you're guilty. You have the right to see, hear, or question any witness called to testify against you, the right to subpoena witnesses to testify on your behalf, and the right to put forth evidence that you believe show a defense to the charge being brought against you. You understand all of those rights?
Yes.
And you're willing to give up or waive each of those rights today?
Yes.
Why are you looking off to the side? Who are you talking to over there?
It's part of the CPS program. She's here to provide with the tablet and stuff.
Where are you now?
At my home.
Oh, okay. You said someone from CPS is there?
Yes. Part of the
Okay.
CPS program.
Let me see who it is. Oh,
Hold on.
thank you. Okay. I don't know why you have to look off to her to answer. But
I'm just making sure that I'm sorry. I'm just nervous, and I'm just making sure that I'm saying the right things. That's all.
well, she can't tell you if you're saying the right things unless
Okay, I'm
there's
sorry.
coercion. You understand that?
Yes.
Okay. You can turn the camera back on yourself. Okay. Okay. So you understand all of those rights?
Okay, that's just
Yes.
weird.
And are you willing to waive or give up each of those rights today?
Yes.
Okay. Are you currently on probation or on parole?
No, just nothing. No, I'm just not until now.
Okay. You're not on probation now. You're on bond.
Okay.
But do you have
no?
other criminal matters pending?
No.
You understand that if you enter a guilty plea, it could result in a conviction that you may need to report to a current employer, or you may need to report a conviction on a future job application.
Okay.
Do you understand that?
Yes.
It also could have impact on where you can travel or get immigration status. You understand that?
Yes.
As to the amended charge of domestic violence, how do you plead?
Guilty? Yeah, guilty, I guess. I'm sorry, I don't.
You plead guilty. You need to tell the judge that.
Okay, I plead guilty, sorry.
It sounds like duress. It's
You what?
duress in this moment. So
He's not under video.
today,
No, I believe it was
Yes, Your Honor.
provided. Yes, it was. Oh, it was today. Oh, okay.
I
It
generally.
was provided today. Your Honor, and I did discuss it with him with my
I don't think it's a good practice, let's say this, for you to accept an offer, ma'am, the day that you got it. You didn't even have time to sleep on it. You could decide tomorrow, I absolutely shouldn't have done that. And you don't have to take the offer today. But you're also appearing to me to be under some duress. When you are giving your answers and responses to me, you're looking off to the side to make sure you're saying the right thing because the CPS worker is there. You have an attorney who just said to you, after you wasn't sure what your answer was, that if you are pleading guilty, so you have to say you're pleading guilty. No, you need to know on your own that you are intelligently and willingly giving up your rights and knowingly pleading guilty on your own. And you're not there. That's not where you are. And that's okay. You don't have to be there. You may never get there because these are your rights by Constitution. You do not have to give them up. You can maintain your innocence if you like and make them prove it. Or you may decide that you want to take a plea, but you don't have to do it the day you find out about the offer, okay?
Okay.
So what I'll do at this time is I can treat next week as another probable cause conference.
That'd be great, Your Honor. Thank you.
That will give Ms. Flores some time to consider the offer, get further counsel from her attorney, and then if she'd like to enter a plea, she can do so in person next week, okay?
Okay.
So we'll see you next week in person at 8:30, March 6th, okay?
Okay. Thank you.
You're welcome. You're all set.
Yeah, have a good day.
Same to you. Devon Robinson Johnson, 25-01903, appearance, please.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Morning, Your Honor. Attorney Nicole Samuel on behalf of the defendant who is present in the court today. Making his way up.
Okay, today was the date scheduled for a preliminary examination. My understanding is that there will not be an examination.
That's correct, Your Honor. Defense counsel is going to be moving to withdraw from this matter.
Based on what?
I will leave that to a statement.
Thank you, Your Honor. I won't get into the details. There's been a breakdown in the attorney-client relationship between myself and Mr. Robinson Johnson, just some communication issues between the two of us. So I have prepared an order for withdrawal if the court is willing to grant it, and I'd ask that he's reappointed.
You got to give me some detail if you want me to grant your withdrawal.
Oh, well, Your Honor, I can give you some detail if the court would like. Essentially, there's just no way for us to effectively communicate when I try to communicate to my client as to what the law says or try to explain some of the detailed provisions of the law. He gets angry and it doesn't go very well. And we've had a couple of different instances of that happening. He's a great guy. I think that maybe it's just not working.
Okay, and you're a conflict counsel.
That's correct, yeah.
What do you want to say for yourself?
I got a lot going on.
You got a lot going on.
Yes, ma'am.
Who don't got a lot going on?
I know everybody got a lot going on.
Absolutely. What's the shirt mean? Kisses my white lady?
This is my brother here.
Oh, okay. Why are you raising your hand, ma'am? How can I help you?
That's my son.
Your son is white lady?
I'm white lady.
Oh, okay. Thank you. So what does it mean that you got a lot going on? What does it have to do with your communication with your attorney?
It really don't have nothing to do with it. It's just like our communication just not working. Like, I mean, it's like,
Are you yelling at your attorney?
no man,
Are you getting upset and aggressive towards your attorney?
no man. Not
Okay, so why does she believe that the communication is broken down?
I'm not getting aggressive at all. It's just we're not going through to each other
Rude to each other in what regard? I'm not following.
regarding the case.
Okay, I know it's about the case, obviously. That's why we're here.
Right.
But if your attorney is speaking to you and explaining the law to you, Are you having a problem with that?
No, ma'am.
Or are you having a problem with what she is suggesting as strategy?
We don't have anything to do with strategy.
Where's the breakdown?
Your Honor, I think that maybe I can help here.
Okay.
I'll be trying to explain what the law is. He doesn't agree with what the law is. He gets mad, and that's what happens. And is he yelling at me? No, maybe he's not yelling at me, but he's talking over me, won't listen to what I have to say. I can't change what the law is. I can explain what the law is, right? I can advise him of strategy. I still tell him it's his choice. And then I get the, well, who are you working for? Are you working for me?
Ooh, I'm wondering if he's a sovereign citizen.
Are you working for them? And I can't effectively represent somebody that doesn't trust that I have their best interest at heart.
I would agree. Sir, you raised your hand.
I'm gonna definitely trust her. And it's not that I don't understand the law. I understand the law very well. It's just, I want them to see my side of the story too.
You don't believe she sees your side of the story.
I'm not sure.
You're not sure.
No, ma'am.
Have you given her an opportunity to have a discussion with you about it? Or is it that you just shut down when you believe that she doesn't understand?
Honestly, I do shut down sometimes.
And how is that going to be helpful if you get a different attorney? Because the law is not going to change. The law is the same, regardless of what attorney is appointed. And you don't get to select which conflict attorney is appointed on your case. You do recognize that.
Yes, ma'am.
The only time you get to choose your attorney is when you decide you're going to go use your money to buy and hire your own counsel, which, according to what we have here, you are not able to do, correct?
Yes, ma'am.
Okay, so unfortunately, I've never dealt with you before, so I can't even speak to her performance. But so far, everything she's done or said has appeared to be professional to me.
Yes.
Attorneys by nature, don't like to lose cases. We're all competitive, right? Attorneys by nature don't want to put their license on the line. Okay, because she's had to work hard to get that license, and so by nature, their job is to advise you of risk. And that doesn't mean that they're not working for you, because the advice of risk, you don't like it. It may be that you have a high, I know nothing about this case, let's be clear. It may be that you have a high risk, but that doesn't mean that there still can't be strategy that you discuss, even after you get beyond her telling you what the risk is. She could tell you, hypothetically, listen, all the evidence is not looking good. And this is potentially what you're risking if we move forward. It's still your decision because it's your rights. I don't care. This is what I want, my side of the story to go forward. And so we can take this to trial or whatever, or we can run this exam, whatever. That's still your choice, regardless of who is standing next to you. You understand that?
Yes, ma'am.
So you think that that's a problem? No, I'm just trying to find out, because I need to find out if there's really a breakdown, or if this is something that will continue regardless of who we put here.
Team.
I don't know that it won't continue. I know we're not prepared to have an exam because I was told that you were filing a motion to withdraw. It sounds like you're uncomfortable with moving forward. I'm going to grant her motion to withdraw. There's going to be a new application that needs to go back to the public defender's office for you to get a new conflict counsel. So that'll delay your ability to have an exam. You understand that?
Yes, ma'am.
So we did postpone. There was 50,000 cash. Wow. Need to back in order.
It's a public offense.
Oh, come on, Judge. Let her out.
That's last, right?
He's a he's for him. And his witness in the life.
How many weeks ago? She said. He doesn't know his wife is pregnant. Oh, God. Oh, it's gonna be a little Mr. Pregnant. Oh, my Lord. We're all in trouble.
Yes, we are.
Okay, I've signed the order. If you could have a seat, I just want to make sure from the public defender's office, they don't need any additional information to run you back through their system, okay?
Thank you, Your Honor. Have a great day.
Same to you. Oh, did I give him another date? No, but should this be? We gotta set it for another PCC. Mr. Etheridge,
Ready, Your Honor.
I just have a question. That young man, the attorney conflict counsel just withdrew.
Yes, Your Honor.
Does he need to do a new application to go back to your office?
I don't think so, Your Honor, because unless it's a really, really old case, I don't think he does because he should still be qualified. She should just let the court or Ms. Riddle know that she motion to withdraw is granted today and they need to reassign for that.
Okay, did you hear that, Ms. Samuel?
I did.
Thank you.
Thank you. I'll make sure that gets done.
Thank you. Best wishes to you.
And I can follow up with her if I have the defendant's name, Your Honor.
His name is Devontae, D-A-V. Is that O? O-N-T-A-E. Yeah, I know. I was trying to read the handwriting in here. It's whoever wrote the file. They made the O look like an A. And Robinson Johnson.
Yeah, by the way, this is all Zach's fault, as is often the case. It's good stuff and lots of it.
25-01903. I'm gonna get you a new probable cause conference date, okay, sir? March 12th at 2 p.m.
019.
Yes.
You said March 12th. March 12th at 2 p.m. Okay, sir? We'll give you a notice in just a moment and then you're on set. You're welcome.
Okay, there came Timothy Alexander. Commonwealth of Kentucky versus Timothy Alexander, 23 CR 0039. You are Timothy Alexander,
Yes, sir.
born in 1982, the last 4
Yes,
years.
sir.
You got a motion to revoke and a pretrial conference. What do we have on the pretrial conference?
First, on the pretrial conference, Your Honor. In district court, Mr. Alexander was charged with burglary and strangulation. When the grand jury heard this case, he was indicted on burglary and assault forward. Strangulation was not indicted on. And the witness appeared the victim in that case. Since we've had this case, I have met with the lady who owns the apartment that Mr. Alexander had I would say, altercation with or dispute with. He allegedly went in and grabbed her cell phone. And there was a dispute about whether she owed him some money or he owed her some money. I can't remember. But anyway, the lady told me that Mr. Alexander had permission to be in her apartment and that she never denied him permission to be in her apartment. So I don't think I can proceed with the burglary case. I've talked to the victim and the assault forward that was defending the lady's honor, I guess, during the dispute. He doesn't want to prosecute the case. So what I'm telling Mr. Alexander's been in jail for quite some time. I've talked to Mr. Garner. Mr. Alexander had a pending positive meth test. So I'd say that might have led to the altercation if he was high on meth. So at this point in time, I'll probably ask the court to dismiss the burglary case and sanction him on the revocation. I know he needs to be set up with a Donta on dual diagnosis treatment, and he needs some IOP treatment for his drug abuse. That's about all I can do.
What's the probation? What kind of
It's
probation?
a 10-year sentence, 5 years probate.
What was that for?
His previous assault. And that's what really bothers me on this case. Mr. Alexander, he'll do good for a while, and it seems like he gets in an altercation with somebody again. And it's probably drug and
How long has he been incarcerated?
gosh, I'd say 3 or 4 months at least. He could probably tell you. Ever since this occurred, I guess. When you look at it.
You wanted to meet with the. Ladies.
Yeah, and one of these times, if Mr. Alexander doesn't change his weight, I'm gonna get something against him. He's gonna be revoked if somebody.
Well, he
goes
might be
back to-
revoked this time. I
Right.
don't know what, you want him to meet with the professionals and see if he needs anger management or drug treatment, or what do you want?
Yes, he needs to get mental health treatment, drug treatment, and anger management treatment, any kind he can have. Otherwise, he's gonna be right back in front. This happened on November 13th of 2025. I believe that's how long he's been in jail. Since November of last year.
Okay, well, I have Mr. Alexander.
Sir.
I will tell you how this is going to end for you. Mr. Stockton said if he gets anything else, he's going to send you to jail. If people are afraid of you, somebody will kill you. It's not a person that's going to stand up and do a fair fight with you that you got to worry about. It's somebody that's afraid of you. I think with some of these histories, these confrontations, you might have some people that are afraid of you. I'm just giving you some unsolicited advice because I don't want you to get killed. Okay. I'm going to go ahead and let you out. Continue and the days that you've been in are going to be service sanctioned. They won't be good days. They'll be sanctioned days. And I want you to, when do you come to probation parole office?
Tomorrow morning, Your
Okay, I'm going to let you out in the morning at
8 a.m.
8 a.m. You go to probation parole office in Columbia, meet with them, and they'll set you up with maybe some anger management or check on your drug use or something like that. Okay? Don't disappoint me. Okay?
I won't, sir.
You get out and get a job. You've always been very respectful. You know, get a job and maybe you can turn your life around. Okay?
All right. Thank
Good
you.
luck. Jason Bowers.
Bowers.
Jason Bowers.
So,
Are you Jason Bowers?
Yes, sir.
Good
I don't
morning.
know who shot.
You're here on 22 CR 0082 for a shock probation revocation. You were born in 1984 and the last
Yes,
four
sir.
digits of social security, is that correct?
Yes, Your Honor.
Okay, you want to proceed with the shock probation revocation motion?
Yes, Your Honor, we'll put on, I'll probably have to call some officers. They may be in the grand jury.
Well, just give me a background of what you say's happened, see if we have a stipulation.
He's been on shock probation since May 23rd of 2024. On January 27th, 2026, officers here locally were called to his residence. He was intoxicated with alcohol. January the 29th of 2026, officers were called. He was under the influence. They thought he might have been driving a car, but he wasn't caught driving a car, but he was under the influence that day. And then there was an EPO entered against him January 30th of 2026. Not knowing the nature of these EPOs, I don't know if that's been dismissed or if it's still in effect or what, because those things are kind of like sand through your fingers.
You're
But
joking, right?
Mr. Sheffitt wants him to go to long-term treatment.
Yes, Judge, we've had him assessed. We've got a bed letter for him for March 5th. I guess it's next week. Next
What is
Thursday.
Tell me something about the EPO or the BBO.
That's something I don't know. That'd have to be pulled up with the clerk, see if it's still that.
I'd like to bring it up and let your staff or someone look at it.
Yeah.
To see what it's about. You got it there?
I do. And Officer Garner said he did complete a 60-day treatment. When was that through Art?
That was August.
When was that?
That was August 24th.
Of
As
like,
soon as he got graded, he got a shock probation.
oh, okay. So it's been about 2 years ago. This looks like it was taken out by Catherine Humphrey. Says when Jason drinks, he gets mouthy and violent. He's been arrested for 2 violent charges and currently on shock probation. Jason has been doing well with drinking after he went to rehab when the shock probation was granted. But then on December 23rd, 2025, he got drunk. And I have a video from the front door blank camera where he said he was going to stab me to death. And I had Paisley on my hip in the video. Fast forward to the most recent incidents. He called a suicide hotline January 27th, 2025. I was in Nashville doing treatment for my oldest daughter, Lillian, who was
Wow, this room gets quite the crowd.
Was diagnosed with a cancerous brain tumor. Jason, my sister, and Liam and Paisley was in the home. He told the hotline that he was going to kill himself, said he had guns in the home, which he does not. Cops was called to my house, Seth Stockton, another cop.
He was going to kill himself.
Nothing happened.
Seriously?
That was, I believe, on January 27th. On January 29th through midnight, Jason was drunk and had told my sister he needed to leave. And I told her on the phone that because I was still in Nashville, to not leave the house with him drunk without the children. He was driving our friend's car that he borrowed, Timothy Davis. I called Timmy. Brandon Poole and Lance Watson was out looking for him. He ended up coming back home. My brother had got there. He was gone. When he came back, he was trying to get my brother to fight him in front yard. The cops came to my house after he got back, talked him down. My sister took my kids and left for the night. He was messaged me after and said, I wish the smoke alarms were still plugged in, but I couldn't catch it in time, and sent me 2 photos. I had a tote box with my kids' old drawing and school stuff in it, and the other, it wasn't in there anymore, insinuating that he had burnt my tote box with their memory stuff in it. I have yet to message and answer or any of his calls and texts. He has threatened to take Paisley, our youngest daughter, and go to Ohio. She's scared of him now. I have her now. Sometime during the night, last night, he had called my 2 oldest children's dad's wife and told her that he was going to kill Anthony, which is my oldest 2 kids. During which the phone call, Vinnie Bragg, my oldest 2 kids' stepmom, said he told her.
Okay, I get it.
Yeah. Kind of been on a rampage. This is according to Catherine Bobby Humphrey.
What do you
And he's on shock for wanting to, I believe, when the original charge.
You want a hearing on this?
Well, yeah, I mean, if the court's,
I'm gonna send it, if
Yeah, I
it's
need
true,
witnesses.
he's gone to the penitentiary. I don't take the people threatening to kill people or threatening to kill themselves or burn stuff. People always say, well, we didn't know he was going to kill these people. Well, people don't say they're going to kill or shoot somebody and burn somebody unless they have the inclination to do that. And so I'm not going to be a party to that unless you can disprove. If they prove he said that, he's gone. So if you want to have a hearing, you can stipulate.
no, I think we need to have a hearing,
I
Judge.
think you do too, because that was hearsay. Okay, we'll schedule.
Can I get my officer recognized and I'll.
Oh, you got officers here today?
Yes.
Well, let's have the hearing.
Well, I don't have Miss Humphrey here though, and those officers didn't write a report. on
Okay,
each one of these.
officers, y'all turn your cameras on if you're there. Any of them here?
They're back to grand jury. We'll check.
Bring them out here, yeah, and we'll recognize and be here on 24. Clerk says the domestic violence hearing is scheduled for the 18th.
I'll see that she's subpoenaed to be here.
Tanya, let's go on to the next case. We're a little early on the civil docket. I'll call the first case to see if the parties are here and are ready. West Bend Mutual Insurance versus Fletcher Excavation.
Judge Mike Van Sickle for the defendant West Bend, appearing via Zoom.
It's a motion for summary judgment. I've read your brief here. What kind of, Mr. Wilkerson, what kind of response do you have?
Judge, we were able to file actually a response today. We were asking for, looking at rule CR 5603, which is the notice requirement for a summary judgment motion.
You need to speak up a little bit.
So, Judge, they filed their summary judgment motion on February the 16th. It was late in the afternoon. We've not had an opportunity to fully prepare and get this.
Let me ask you something.
Yes, Judge.
I've knocked this case around for quite a while. What is their defense? They've been given an opportunity to provide proof that this was wrong, this was wrongfully paid and that they made payments on it. But up to this point, according to the brief of the plaintiffs, they haven't shown where it was wrongfully paid. And then do they have any proof that it's wrongfully paid, or are we just kind of knocking this thing around?
I don't believe so, Judge. And the reason being is on two different fronts. Looking at this, prior to, I mean, this is an action on a surety bond, right? And so there's
Indemnification, right?
That's right.
Yeah.
Indemnification. I believe the facts come down in two different buckets. And one of the buckets is, how did the claim get settled? The underlying claim that was made by a supplier against the surety, right? And how was that claim settled? And we believe that.
Okay, well, let's stop it right there. The underlying claim, okay, so this job was bonded.
That's correct.
Okay, and then the underlying claim is because your clients did not pay for materials. And so the plaintiffs went against the bonding company who had bonded, paid some things, received payments, but have never, you're saying there was an unfair practice or something in settlement, but you never have shown any proof that your clients paid for this material and therefore the payment by the bonding company was improper. And I think that, I've read and reread this thing, and I think that's the crux of that. Now, and some of these other defenses you made under fair practice, I don't think apply to a commercial situation like this. I think the plaintiff is correct on that. I'm just asking you plain out, does your client have any proof, which has not been provided to the plaintiff, that they paid this and therefore the settlement which they seek indemnification for should not have been made? It's a simple question.
Well, the reason why it's not as simple is because
it's a simple question for me that I want to answer.
There was, okay, so, but again, we have to look at this in two different buckets, Judge.
Well, this is the bucket I want to look into it. And
Right.
if you got an argument that will change whether they're responsible for it, I just want to know if your clients have any proof that they made the payments and the payment by the bonding company was improper and against their interest, and that they shouldn't be able to be indemnified.
The amount, Judge. So if we're talking about tip to toe, right, if it was like there's absolutely no obligation to the supplier at the original outset of this, right? If we're saying that there is the obligation was totally wiped clean by my clients before the bond company paid.
And they paid it?
Have they paid it?
Did your clients previously pay?
Prior? No. But the dispute is with regard to the amount, right? The dispute is with regard to the amount.
Well, we need proof as to the amount. The proof is to the amount. If your clients paid half of it, then the bonding company should have just paid for half of it, and you'd be allowed an offset against this indemnification judgment. That's what I've got to know. Do you have any proof where your clients paid for any of this material that was supplied?
Well, in the course of discovery, we requested a myriad of documents to which West Bend has provided most. I don't know if all, but most. And inside that, there were invoices from the underlying supplier for the original claimant.
What proof do you have by your clients that they paid any of these bills? I don't think it's that incumbent upon the bond company that the bond company paid a claim for unpaid materials that your client they say did not pay. I don't know whether your client paid or not, but I've seen no proof. All this time we've been jargling this case around. You've had an opportunity to come in and bring proof that your client paid this and that the bond company inappropriately paid that bond off. And I haven't seen any of it. And when I ask you straight up, you don't give me any numbers.
Okay, well, so yes, there were offsets. And so the claim wasn't about money actually having been paid. We believe that there were checks that were actually paid. The underlying claim is by Consolidated Pipe. Yes.
Your client.
Them or the person, the principal who would have been issuing the checks on the job, right? They would have diverted payments to Consolidated Pipe, which is the underlying claimant against the bond. The supplier of pipe, this is an excavation company. They were saddled with big jobs. Barron County Board of Education, did some stuff for Western Kentucky University.
There's proof that your client paid for these materials or someone paid for these materials on their behalf? Where is that proof?
We believe that there is at least some amount.
Well, what amount? See, I can't, this has been going on, this discovery has been going on and back and forth. You have to give them some discovery too. And we could end this case and get around all this stuff. If your client, are you saying your clients don't know how much they pay?
To be candid, no, we do not.
Well, that's a problem.
That is a distinct problem, and we've been earnestly trying to get to that. A lot of it also hinges on the amount of offsets. This consolidated pipe, the original claimant against West Bend's bond, they had a lot of different projects going on at various different times, and also in conjunction with one another. I mean, there was like a job in couple of jobs in Bowling Green, Glasgow. But again, Judge, that's not the crux of this. And what I'm saying is there were offsets. There would have been a return to materials. And that we don't believe that there was adequate offsets provided.
You need to provide proof of that.
And we believe with the invoices that have been provided through the discovery that we requested, we've been able to at least make a showing of that. I'm asking today.
I haven't seen it yet.
Judge, and that's the thing. They filed this less than 10 days ago. And so under the rules, and I've cited the case in our response, I understandably it's a hurried response, but so is the motion itself. I mean, the rules clearly state that it needs to be more than 10 days. And so also with regard to that.
Let's attorney for the plaintiff speak here. Go ahead.
Judge, we've got no objection to allowing him at least 10 days, passing this for a hearing on another date and allowing him time to file an actual response to our motion.
Okay.
Well, that sounds.
Okay, you file one within 10 days from today.
A response.
A response, and in that response, I want you to outline the payments or offsets you feel like your client is entitled to. Is that unreasonable? This case was filed.
If that's not the only issues at play here, Judge.
Okay, what's the other issue?
The other issues at play, and again, I hate to harken back to these two buckets, but it really is, right? After the bond was, the bond issued supposedly a payment to West Bend, which is also somewhat of a factual dispute. We've asked for the check that was actually written, a copy of the check that was written to the.
Okay, let's stop it. Do you have a copy of the transfer of funds or checks?
Judge, I requested that from West Bend, and they were able to send me like a screenshot today showing where essentially, I think a screenshot of their bank account maybe showing that it cleared, and I think they requested from their bank, but the bank doesn't have a copy of it to give to them, probably because it's been 8 years. I don't know, but either way, they said that they don't have an actual copy of the check, but they did send me essentially a screenshot of their account showing that with the check number and the amount paid to consolidate it, and then check close.
What else do you need?
It's within their internal ledger. And we also would never received any sort of release or proof that the underlying claim was ever released or there was a lien release. But again, that's just maybe a segue into the second bucket, which is the parties may very well went into a brand new deal. This installment agreement that the Fletchers were then making payments to West Bend, admittedly so. We believe that there's, I would like some more time to prove to the court, not only the first set of circumstances and facts that you're trying to get at, as far as are they owed any sort of offset? Did they make any sort of payments that would have eroded that claim that they're making? And the second one is once the Fletcher started making payments, was that a novation? Did that create a brand new contract with brand new terms? Because part of this, Judge, is that they're asking for attorney's fees and interest owing pre and post judgment interest, but and a lot of that is derived from the original indemnity agreement. And so after this claim was paid to Consolidated Pipe, supposedly, again, we've not seen the actual check that was written or a release that Consolidated Pipe granted to the surety company or my clients. But then afterwards, once there was an agreement that was sent out and said, hey, we're here and we're going to try to collect on this payment that we've made to one of your suppliers. What can you do? And then they start making partial payments and actually send
Did that
them.
happen?
It did.
Well, have you got proof of that?
Yes. Yes, we
I
did.
haven't seen.
And again, Judge, if we'd had adequate time to
You're going
bolster
to get
this.
adequate time, but look, you've had years. There've been years. How long have you been involved in this case?
I got into it last year, Judge.
Last year is
That-
the operative word. So I want
That's right, Judge.
wait. I want some action done. I'm tired of fooling with this case. Your clients need to put up or shut up. Okay. And I want some proof on what you say on payments that they made or payments. I mean, you surely don't think that someone's going to try to come back on them and collect for this material that they allegedly didn't furnish. It's been paid off. Now the bonding company paid it off and they want their money back. Okay. Now, if you can show where your clients paid any of that debt before the bonding company do, I'll give you an offset for it. Okay. If you can prove that they made payments after that to the bonding company, you say they made payments to the bonding company? Is
Yes.
that if they paid payment? If they do, then we'll address that issue. But at this juncture, the motion for summary judgment is up and you haven't given me anything to go your way on at this juncture and you got 10 days to do it. Okay. Thank you very much.
And Judge, may we have 7 days to reply?
How many?
7 days after.
Yeah, you have 7 days to reply. Thank you very much, everybody.
Thank you, Judge.
That's all I have.
Yeah, absolutely. Have a safe journey. Shootman versus Housing Authority of Burkesville.
Yes, sir, Your Honor. Matt Cook for the Defendant Housing Authority.
Yeah. Yeah. Mr. Cross is here. Mr. Cross, you have filed a response to motion for summary judgment today.
Yesterday.
I got it today, so.
Sorry, it was filed as the rules require yesterday.
Okay.
I received it yesterday afternoon, Your Honor.
Okay, now what do y'all have to say about this? This is tar paper coming through the crack of the ramp.
This is State of Kansas versus Jennifer K. Kingsley, case number 2024 CR 130. Jennifer Kingsley appears at the Butler County Judicial Center Zoom location. Richard Paul appears as defense
All right. Does anybody want to be a judge after that?
counsel. Brett Sweeney on behalf of the state of Kansas.
I don't.
This matter comes before the court at this time for review of sentence due to probation violations that have been alleged in the case. Do you want to go ahead and state those? Failing to obtain or maintain employment, discharge from the MRT program, failure to complete alcohol and drug treatment, failure to make payments as alleged by Ms. Ashenfelter from Community Corrections. What are your client's intentions, Mr. Paul?
Judge, there's also an addendum to the original warrant that was filed February 24th.
What does it allege, counsel?
Judge, it alleges that on February 12th of this year, she tested positive for methamphetamine and amphetamine at 7th Direction. On February 17th of 2026, she's tested positive for methamphetamine and amphetamine with 7th Direction. On January 12th of
Yeah, that's sad. I mean, you can see it.
2026, she tested positive for methamphetamine, MDMA, and amphetamine at 7th Direction. And then on January 20th, she provided a diluted urine sample with the allegation is at 7th Direction. And then the last one is on February 26th, 2026. She was unsuccessfully discharged from outpatient treatment.
What are your client's intentions regarding all of these allegations, Mr. Paul?
Judge, she is she is going to forego her evidentiary hearing, waive that, admit to the violations, and proceed to disposition at this time, Your Honor.
Very well. Ms. Kingsley, you may with you one more time. You do have the right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence with the assistance of your lawyer, present your own evidence at the hearing, confront the state's witnesses unless good cause was shown, and among other lesser remedies, Ms. Kingsley, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your 15-month DOC sentence locked up. Do you understand these things?
Yeah.
Do you waive a hearing in this case and stipulate and agree that you committed these violations that have been read into the record? I didn't hear you.
Yes.
Okay, thank you. It does appear that Jennifer Kingsley waives a hearing in the case and stipulate and agrees that she's committed the violations as alleged. These are substantial and material violations of the terms and conditions of Ms. Kingsley's probation. We'll now turn to a dispositional phase in the case. I'll take recommendations. Mr. Sweeney, what are yours?
Thank you, Your Honor. The state is recommending a 60-day jail sanction. I believe, and it looks like that she's done, according to Chrissy, 4 previous jail sanctions that have been internal through the probation office. So she's actually satisfied some of the, she satisfied the graduated sanctions that would be necessary to revoke her. But it looks like she hasn't had one through the court yet. But certainly I think she needs something elevated above and beyond what a normal dip would be. 60 days, then placed back on all the same and previously ordered conditions, attorney's fees if appropriate.
Ms. Ashenfelter, could you confirm 4 previous dip sanctions that your office has handled?
Yes, Your Honor.
2 or 3 day?
There's been 2 2 days and 2 3 days.
Thank you. I appreciate that information. Mr. Paul, your recommendations regarding an appropriate disposition?
Your Honor, this is her first time in front of you, Judge. She did do those internally. You know, just looking at the warrant to show cause and the addendum, it appears that Miss Kingsley is, still struggling with her addiction. What we would ask, Judge, and I believe she has already 7 days that she previously did just before she made bond on this case. That's what Miss Kingsley tells me. I believe that she would benefit from a new drug and alcohol evaluation. I would ask that those 7 days serve as her sanction on this, and then I believe an extension is appropriate.
Thank you, Mr. Paul. Ms. Ashenfelter, what do you think about Mr. Paul's proposal?
Right off the bat, her extension, she's already been extended until January 2nd of 2027, so I don't think she needs another one. Honestly, I think Ms. Kingsley needs to take a little time and sit in the jail and reflect on her decisions that she's making. She hasn't made very much progress on probation at all up until this point.
Yeah, I mean, this is depressing, but it looks like the only thing you can do is keep her incarcerated or she'll die. It's that simple.
I'm still willing to work with her. She just needs to make some better decisions.
Thank you. Jennifer Kingsley.
Yeah.
This time the court will address you personally, and I'll ask you, do you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court?
I just don't want to do any jail time and go find another drug and alcohol place to go to. Or try to find an inpatient or something.
How come you haven't done that up to now? Because you've been on probation since January of 2025.
I've been looking for my intern. I'm waiting for my insurance to find which one I can go to. I've been working on, I've got a side job where I can make weekly payments on my fines. I'm just asking, jail time and give me another chance.
Ms. Kingsley, it sure appears to the court that you've had a number of chances in the past. Your original probation, and then 4 different dip sanctions, where each time you obviously were in violation in some way, and community corrections worked with you and did an internal dip sanction in jail. Court's empowered just to outright revoke you today and send you to prison. Quite frankly, Ms. Kingsley, that may be the best solution about sobriety for you if you're not going to do it on your own.
Well, I've been calling around to go to inpatient treatment. And I've been calling for a while.
It's been over 13 months since you were sentenced.
I know.
learning from my mistakes slowly, but I just want to know.
I don't see that. I mean, I'm sorry, I don't see that you're learning
I
from your
know,
mistakes.
I've been job interviewing. I got a couple of job interviews after here if I can get released. I know I promised in the past, but I'm really meaning it this time. I'm really wanting to better myself up. I just don't want to do jail time. I just want to go get jobs, do what I can do, find inpatient treatment. I'll even ask Kirsty to help me find an inpatient treatment to do something. I'll even call her right if I get released from here to go. Because I'm supposed to call Cherry Creek back.
When somebody is out in the community on bond and they're asking for inpatient treatment, it almost makes me wonder if you still need to be detoxed. In other words, you're still using?
No, I'm not. This is before even I had that warrant. I've been calling around. I'm just
Another thing inpatient treatment tells me is you won't be responsible enough to attend outpatient treatment meetings. So you need to be confined in a facility.
That problem was because I had transportation issues, but I got a lady that can take me back and forth to my places I need to go.
Jennifer, how old are you right now?
37.
Here you are, almost right at the precipice of being in prison.
I'm just saying, can I please get a second? Can I please get another chance? I know it's in the past,
I mean, that's a rough 37.
but I will work harder. I promise. I got a second job interview later on, but I'm just asking for you to give me another chance.
You realize this would be chance number 6.
Yeah, I know, and I promise I will not fail this time.
Did you say that after any one of the first 5 phases of this?
No. And I've been going to church and everything. I just want to, I'm doing a lot better than I was, but I got a couple job interviews. I got online schooling. I mean, I'm doing better for myself, but I just want to get this done. I just want to not go to jail and just where I can pay my fines, do what I got to do, and make you guys happy. And I promise you won't see me again.
It always bothers me, Jennifer, that people.
Yeah, I'm almost 20 years older than her. But I don't do math.
People, when they get before the court on a warrant to show cause alleging probation violation, they act like they all of a sudden get it.
No,
it really makes me feel bad because I go to a lot of detail at time of your sentencing, telling you everything that you need to do, just how you need to do it to be successful. And you act like that.
No,
well, I didn't take that seriously.
No, but there's like
It makes me feel unimportant, Jennifer.
No, I promise you, it was my transportation issue problem, and now I don't have to worry about that anymore because I got a lady that will take me back and forth to every probation, every class I need to do. You know, I'm doing a side job with her, which I get paid weekly payments on my fines and everything. I'm staying clean, so I'm just asking for another chance, and this is the last time.
Well, I think that's a fairly astute observation. Court notes the defense position in this case. The court also notes the state's position in this case. Court understands the position of the officer making recommendations to the court at this time. Ms. Kingsley, I consider community corrections to be a resource.
I know.
They are there to help people be successful on their cases. Okay, that's the only reason for them to exist.
I know. And I'm supposed to.
And what?
I see Christy on Monday, and I'm gonna ask her more resources, and
I don't want their resources wasted.
No,
on somebody who's not going to try.
It's not going to get wasted. I promise you that. I promise.
Well, this court concurs with the position of the prosecuting attorney and the community corrections officer in this case that extended jail time is necessary here. I understand you're begging not to go, Ms. Kingsley, but you certainly earned it, and you as I stated earlier, you're right on the edge about going to prison, because if you're not going to work probation, the alternative is prison, and was from the very beginning. So the court will order the defendant to serve 60 days in the Butler County Jail. I think that Ms. Kingsley may have made the statement about 7 days of previous credit. Who was able to ascertain that's what she did? Brett, do you know?
Well, at least according again to our documents, we show her booked on 1/28/26, released on 2/2/26, which would have been 5 days.
Okay.
There's more than that. I guess we got that from the jail.
Well, whatever jail time credit she has accrued waiting on this hearing will be credited against the 60 days. And she'll need to serve the remainder, which I'm going to, at this point, presume to be 55 days according to jail records. And then I'll reinstate the defendant one more time on community corrections probation. The first thing you need to do when you get out, Ms. Kingsley, is to contact Ms. Ashenfelter. Would that be by phone?
Yeah.
Well, I'm going to ask the officer that. Or do you need her to come in person?
Your Honor, by phone is fine.
Okay, you need to contact the very first day after you get out. Ms. Kingsley, need to contact Ms. Ashenfelter from Community Corrections. In other words, it's not going to be her job to chase you down after you get out. You need to contact her.
Yeah, because like right when I bonded out, I called her right then and there. So
Okay, well, you need to do that again when you get out of jail. Okay? 55 days from now. Any previously established condition remains in effect. The court specifically directs that an appropriate treatment program be determined for this defendant. She is ordered to successfully complete an approved treatment program, whether it be inpatient or outpatient. No more excuses, Jennifer. You need to just make sure to arrange your life in a way that you can comply with your probation conditions. No more drugs. Drugs are bad for you. And I hope that we don't have to review this sentence again. All right. Further fees are waived given the court's what appears to be a long-term incarceration order. Anything that was previously ordered remains to be owed, is owed by the defendant and needs to be paid. All right. With those rulings made, Mr. Sweeney, do you need any further orders or clarification from the court?
No, Your Honor.
Mr. Paul, are you aware of anything further at this time?
No, Your Honor. Thank you.
Ms. Kingsley, but for your attorney's advocacy on your behalf today, it is likely you would have gone to prison. But I do believe that Mr. Paul, I think, has successfully argued to this court that perhaps with proper motivation, you can still be successful on this. And again, it is the first time that you've been before this court, but I'm disappointed that Christy tried to work with you all of those times and that you had all those dip sanctions and you still didn't change your behavior significantly. Maybe this time you will, and I'm willing to give that one more chance. I hope you're successful, Jennifer. I'm going to remand her custody to the representatives of the Butler County Sheriff's Office at the court security location until her custody can be transferred to the jail to serve the remaining balance of the 60 days that has been ordered. It does appear that she clearly has 5 days of jail time credit. So about 55 more days. If there's nothing further then, the Jennifer K. Kingsley matter will be in recess at this time. I think that's the last case on the docket, Mr. Sweeney.
sure.
That's actually, Your Honor. Thank you.
All right, Ms. Ashenfelder, thank you for your time and input here this afternoon.
Thank you, Judge.
And as always, your services, Mr. Paul.
Thank you, Your Honor. Appreciate it.
There's nothing further. The docket is concluded at this time. The court is in recess and the meeting may be ended for a while. Have a good weekend, folks.
Thank you, Judge.
Thanks, Judge.
All right. The gentleman we just had. All right, now I need an attorney. Good. Our next case here today is People of the State of Michigan versus.
Yeah, these have been good, but a little serious. Let's get something funny.
Levi Evan Spears. This is case number 6-142. 01FH. Before the court this morning is Ms. Dean Stark from the Wexford Misaki Department for Community Corrections. The defendant, Mr. Spears, who's currently in custody, is now here at the defense table. The court also recognizes. Go ahead. Tell me who you are.
Nate Carnes on behalf of the people.
Oh my gosh. All right. Thank you. And now we're just waiting for Mr. Harrison. Samantha, do you do karaoke?
No, I don't.
No? Ms. Stark, do you like to do karaoke? All right, see if we get somebody to sing.
Located.
All right.
I heard you had good reviews last time you sang
Yeah.
there.
I know I'm going to come up with different songs.
What's this karaoke business?
I like singing rap songs as if they're good. It takes two to make a thing go right. It takes two to make it out of sight. Here he comes, everybody.
I'm sorry.
Jeffrey.
Make you wait either.
Jeffrey Douglas
Thank you, Judge. We needed that on this stream.
Harrison is here in the courtroom, and we're here today for a alleged bond violation arraignment here today. Mr. Spears was here earlier this week. That was, I think, a couple days ago, or 2 days ago, on February 25th, for an alleged bond violation. He admitted to that violation had to do with failing to test. The court released the defendant or allowed him to continue or be released on his continued bond. But it ordered him that he appear for testing. And the defendant did appear for testing that day after being released from the Wexford County Jail. He appeared at the Community Corrections Office and allegedly provided a sample and where he tested positive for fentanyl. But he was also found to be possessing a container allegedly with urine on his person, meaning it was either someone else's urine or fake urine. And yes, there's a such thing as fake urine. Mr. Harrison, how does your client wish to respond today?
Wishes to make an admission, Your Honor.
All right. Mr. Spears, please raise your right hand to the best you can. Do you swear or affirm the information testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
I do, Your Honor.
You may lower your hand. All right, so Mr. Spears, you do have the right to due process here today, and that is to require the prosecution to put on some evidence to demonstrate that there was a bond violation. That wouldn't be a trial. It could be considered an allegation of contempt for failing to comply with the court order, but we don't do that. We just treat this as a review of pretrial release conditions underneath what's called Michigan Law 6.106 paragraph H. However, I'm told today that you're going to admit to testing positive and possessing either fake urine or urine that belonged to somebody else. Is that what's going to happen?
Yes, I'd also like to just apologize to the court and to Community Corrections for just not being honest in the first place.
Has anybody made any threats or coercion to get you to make this admission today?
No, Your Honor.
So, Mr. Spears, is it true that when you left the jail and you came to Community Corrections, how long did it take you to get from the jail to Community Corrections?
While my ride didn't show up, I ended up having to walk. And then I was cold. I ended up going to the store and then calling for a ride up to the courthouse.
All right. What store did you go to?
I ended up at Shell.
The Shell gas station?
Yeah.
The one, is there two? Remember?
Close from.
Oh, the Shell gas station is down by the old Cobbs Mitchell building, or the Cobbs Mitchell building, or whatever it's called. I got it.
Okay.
All right, and then you got it right up to the courthouse. Okay, and when you got up there, did you take someone else's urine or a fake urine sample?
It was actually an old sample of my own.
Okay, and
I was just worried.
I got it. And
I had been using heavily before I got arrested.
All right,
and I was scared it would still be in my system when I got released.
Yep. All right, and apparently it tested positive for fentanyl. Is that correct?
Yeah, I had been using heavily before I got arrested in the first place.
All right. The court finds the defendant to have violated the terms and conditions of his bond. His bond requires that he's not to use, possess, or consume any illegal or controlled substance unless provided by a through a prescription from a medical provider. You didn't have a prescription for this, correct?
No, I had been struggling with addiction before jail.
I understand.
It wasn't a
All
great
right,
plan.
thank you. All right, so now that we're, Mr. And I'll remember from Ms. Stark told us and talked about last time, has there been getting tested before that, correct? That was a yes. Left, right there, Nancy. All right. Mr. Carnes, what do you think we should do? What's your position?
Your Honor, again, this case involves a defendant stealing a vehicle while intoxicated, certainly by alcohol, possibly other controlled substances, and then crashing that vehicle. So there's a victim out of the vehicle that was totaled, and the community was put at danger, and the defendant is now testing positive and is using it prior occasions. I think a remand is the only option here. I'd ask the court to impose that. Thank you.
Mr. Harrison, your position, sir?
Well, believe it or not, I disagree with that assessment of the situation. These are clearly acts of desperation by someone in the throes of an addictive episode. You know how addiction goes, Judge. You're sober until you're not, right? And that's exactly what happened to Levi. I wish he hadn't connived to attempt to defeat the drug test. He wishes
Thank you, counsel, for saying nothing.
that too. That's part of what he wanted to express to you. Ironically, when they first brought him in, they attempted to test him at the jail and he was unable to provide a sample, so they neglected to test him, released him to community corrections. He had reason to believe there would still be fentanyl in his system. And the rest is what he told you. I'm happy to announce as well to the court that most of the conversation I had with Levi this morning was centered around his desire to go to rehab. And we're going to try to find him a spot as quickly as we can. Obviously, if he were released on bond, now that process could be streamlined. We wouldn't have to make a motion for release or modification of his bond to accommodate that. I don't know what else to say. I see this as he recognized he had to stop. He tried to stop. He got arrested in the interim, et cetera, et cetera. This isn't, I hesitate to use this term, this isn't new use, and he has no intention to go back to use it. It's just something that happened and the times overlapped, and here we are.
All right. All right, thank you. All right, so here we go. I've already heard here from Mr. Spears about what happened. To call something an act of desperation also suggests that there must be a response. Because if someone is desperate and needs help, well, the court needs to find a way to help get them that help. Also, let's not fool around here. The defendant went from the jail, which is that way, about half a mile, past the courthouse, and went to the Shell gas station. By the way, of course, I know the Shell gas station. That way, another half mile or 3/4 of a mile, and then came back here somewhere between there, and here, this diagonal triangle. Sorry, we should start calling it the Westford County Courthouse Triangle, kind of like the Bermuda one. And then somewhere in all that, he got extra urine that he kept. Don't know where he kept it. I doubt he kept it there at the jail. So he must have really gone someplace to either get old urine or what else is, I don't know. But he didn't go straight. I can do.
Your Honor, there are text messages in this petition. Shows he has people conspiring to get him urine.
Oh, yeah.
Outside.
Yeah.
Those were attached to the original.
Yeah. Oh, that's, oh my
Better
gosh.
support network.
Yeah. Oh, I even see that on there. Nadia Yates, the person with whom he's texting, had videos or clips of our video. And that's okay. I mean, it's not a big deal. So clearly she knew what was going, and it said, I need clean pee ASAP. Got to take Levi to courthouse. So apparently he had a ride someplace. But clearly, I'm just going to say I think the defendant's lying today. But he wants it's an act of desperation. Ms. Yates, if you're watching, shame on you and helping somebody violate a court order. So, and Matthew Gray.
This is bizarre.
Good job, people. All right, the court revokes the defendant's bond, remands him to custody of the Wexford County Jail. You can seek to try to get him into a program, Mr. Harrison, but you're going to need to convince me that I do it. I will remember that he and his buddies, his friends, tried to pull one over on the court at Community Corrections. My likelihood of granting him a bond modification between now and the time this case is resolved, extremely low, almost zero. Thank you, Judge.
Joyner, come on up. I mean, I'm sorry, not Joyner. Stringer. Okay, Mr. Stringer, you grab that seat right there.
Sir.
Let me pull your file up. All right. This is the case of the state of Georgia versus Christopher Stringer, 25 SR 0282. Mr. Stringer is seated at the defense table. Ms. Sexton is here representing the state. I know very little, and so Ms. Sexton, I may have you fill me in. I just know this was called for a trial with Judge Essery when I was doing the civil jury trial.
Yes, Your Honor.
And I believe Judge Essery ruled from the bench that Mr. Stringer wanted to release his attorney and represent himself.
Yes, Your Honor.
Anything else that you need to put on the record as far as contextualizing how we got to this moment?
Well, the only thing that I would like to advise the court, since you weren't there, and as Judge Essery was that this appeared on the trial calendar. The state had two
fighting this without representation as a proceed.
bench trials, and the defendant was represented by the Jukes law firm. And prior to the court hearing, I had asked Mr. Charles if we would be able to continue the case because we were already dealing with trials that we were trying to get ready for. And Mr. Charles, who was representing the defendant at the time, agreed to that, knowing full well that the state had not previously asked for any continuance. This would be the first continuance, and just by procedure in this courtroom, each side is always, by matter of procedure, allowed their initial request for a continuance. At that point in time, the defendant stood up and said that he was not agreeing to a continuance. And when the state presented to Judge Essery that we were entitled to a continuance, we hadn't asked for it before, and Mr. Charles consented to that. The defendant then on the spot fired Mr. Charles, and then Judge Essery asked from the bench to perfect the record that Mr. Charles was being released from the case, because at the time there was no motion to withdraw or anything like that. So he was released. And then when Judge Essery agreed to allow the state's continuance, the defendant asked to be heard. And when he asked to be heard, he presented his case, that his case should not be continued, and then proceeded to present the court with motions.
Okay. All right. Thank you for that. Mr. Stringer, is there any context you want to just put on the record to help me get myself fully up to speed?
Yes, Your Honor. Pretty much what happened, I was talking with with my attorney, and he was saying, I'm going to ask for a continuance. I was like, well, I can't do a continuance. I have my custody hearing that's coming up. I can't do a continuance. And he was like, I don't care what you have to say. I'm the attorney, so I'm going to ask for a continuance.
Okay.
And so at that point, I was like, well, if you're going to do that, then I'm just going to go ahead and represent myself instead of letting you ask for a continuance. So there was no precursor of any discussion about it prior to that. So I just went ahead and released them so I could go ahead and defend myself.
Okay. And it's your wish to move forward with this case representing yourself. Is that correct?
Yes, Your Honor.
All right. Well, then I'm going to find that although I was not there and have not, I don't believe there's a transcript, but Judge Essery did inform me as he left out that he'd had a defendant that he'd had a full Feretta hearing on, which is the letting your attorney go hearing, and that he had found that all of that the defendant wished to release Mr. Charles. Defendant had that right. You have a right to represent yourself as much as you have a right to have an attorney. And so you're electing to represent yourself. And so I told him that when I encountered you at the next and he told me that he'd scheduled it for hearings for today. I told him that when I encountered you, I would confirm all of that on the record and that I would place an order in the file saying officially that Mr. Charles was withdrawn from the case and that you wish to represent yourself. Now, I am also obligated at this moment to tell you, Mr. Stringer, that you may still hire a private counsel, although you may not go back to the public defender's office. So that's who you had and that's who you get.
Yes, Your Honor.
And they're out. Do you understand that?
Yes, Your Honor.
All right. That was a yes. All right. Well, then we're good to go on the who's representing him and what do we have. All right. So for today, my goal is to just get my brain wrapped around what do we have? What needs to be done? What can I do today? And what do I need to put off for witnesses and whatnot? So as these are, I believe the majority of what I'm looking at are Mr. Stringer's motions. I would love to hear from you, Mr. Stringer, first. What is it you're expecting to hear or see from me today if I do what you want me to do?
I went ahead and prepared a statement so we could just kind of get to the point. If that's okay.
Go ahead. Just read nice and slow because Miss Terry's taking down everything we're saying.
Yes, sir. Yes, Your Honor. Your Honor,
Oh, good Lord. This should be special.
request dismissal today based on prejudicial discovery noncompliance and due process concerns. Witness names may have been disclosed, but key underlying evidence was not timely produced for meaningful suppression litigation and cross-examination under OCGA 17-16-4, 17-16-6, as well as 17-16-8. This court authority to impose sanctions and immediate remedies under Brady, Giglio, Kyles, and Strickler. Material evidence affecting guilt and credibility must be disclosed in time to be used. The prejudice here is present and concrete. A continuance rewards noncompliance and does not cure fairness today. I request dismissal now. If the court declines dismissal,
Prejudice is present and concrete. Oh, shit.
Request exclusion of undisclosed evidence and derivative testimony. If exclusion leaves the state unable to proceed, I request immediate dismissal today.
Okay. All right. So what I just heard mostly was that you would like a dismissal due to procedural discovery violations, which have precluded you from properly preparing a defense in your case. Did I sum that up accurately?
Yes, Your Honor.
Okay. And that you are of the opinion that even if the state were to provide that discovery, I think
I love pro se's never understand the insult when the judge has to summarize your argument and make it and make it somewhat rational. They're trying to wrap their head around it because you did such a bad job communicating it in the first place. Like, I don't know exactly what you said, but did you mean this? And none of them even get offended. They don't even realize that that's a bad scenario.
I heard you say that you've already been injured, so to speak, and to the point that that cannot be undone. Did I get that part right?
Yes, sir.
Okay. All right. Anything else before I pivot to Ms. Sexton?
Just give me 1 second about the omnibus. Also incorporate the reference. Also incorporate by reference it's might be a little repetitive, but just wanted to make sure I got everything. I also incorporate by reference my filed omnibus pretrial motion and all grounds previously filed for courtroom efficiency. I am not rereading of every paragraph unless the court wants.
No, please don't do that.
Yeah.
Oh, good Lord. This is the short bus on the omnibus.
I can read it.
So. But also, just first dismissal for prejudice, discovery, noncompliance, and due process prejudice under FCGA 17-16-4, so 17-16-6 and 17-16-8, as I said before, with Brady, Gilio, Kyles, and Strickler. Second, if dismissal is denied, exclusion of all undisclosed evidence and derivative testimony under OCGA section 17-16-6 and Wong Sun principles. Third, if exclusion leaves the state unable to prove essential elements, dismissal or directed verdict under Jackson.
Yeah, I was just going to say that. I'm getting AI vibes here. I really am. It's like very AI sounding, just sort of platitudes and nonsense. It's sort of generic language, but language he wouldn't use, and he's reading it. I'm getting real AI vibes.
Versus Virginia and OCGA section 17-9-1. Fourth, explicit findings of noncompliance, prejudice, and remedy for the record. And I am ready to address the omnibus ground briefly on the court's direction.
All right. Thank you. All right. Ms. Sexton, fill me in on this, what this looks like from the state's perspective.
Well, Your Honor, from the state's perspective, these charges are all extremely serious. We have a victim who has who suffered the material loss of a substantial part of their vehicle when it was allegedly hit by the victim, by the defendant, who then drove away, and so on and so forth. The state provided documentation to Mr. Jukes, who requested standard discovery requests. The state is currently trying to determine if there's more than one video, which was a question that was on the table. I believe that the arresting officer was Georgia State Patrol, which typically they just have a dash cam and not a body cam, but it is not for lack of us trying to determine whether or not there's additional camera footage. And I believe that the state has done everything that they need to do. The judge should note, the court should note that the date of this incident was just barely over a year ago. And for a case with so many charges and so many serious charges, and given the backlog that the state court normally has, that this case has progressed rather rapidly through the system. We are about to try this case in April, which is just barely over a year since the incident. The incident was the end of December of 25.
Okay, thank you. Okay. And y'all have
I'm sorry,
served,
that would be 24, Your Honor.
I translated what you meant. So y'all served all discovery within your possession? Is that correct?
I believe we have, except for we're hunting down the body cam.
Sure. All right, but y'all are
And
not,
it may not exist, Your Honor.
sure, y'all are not in possession of it though?
We are in possession of one dash cam, which I have instructed to download onto a flash drive. And that's the only thing that I'm aware that we have at this time. But we are trying to dig, for our own purposes, we're trying to find it.
Sure. And have you served these items in your possession on the defendant?
To my knowledge, we have probably served them onto Jukes, but it may not have translated.
All right. That's a great question. Mr. Stringer, have you received a copy of your file from the Jukes Law Firm?
Yes, Your Honor. They told me that the only evidence that they had, and they said they asked them again if they had any more evidence, and they said no. The only one was a dash cam of one cop car showing up after everything was finished.
Okay.
So that would be the dash cam that I was saying I was going to download onto the flash drive, so I don't even.
So they have that, and they gave that to you?
Yes, Your Honor.
Okay. So you're in possession of the video that the state
They're in
says they.
possession of what we're in possession of.
That's what I'm trying to make certain the record is extraordinarily clear that there's no other items in the state's file that has not been served on the Jukes Law Firm,
To my knowledge, that is correct.
Okay, perfect. And then, all right. So, Mr. Stringer, anything else on the discovery argument before I make a ruling on that?
Just the fact that if, it's just non-compliance to be able to get the discovery when it's asked for it. And if that's all that they have, that absolutely shows nothing. It shows two people standing there.
Well, what it shows is not part of the question today. The question is today, you're alleging discovery violations. Discovery violations is when they say, I've got this amazing document that shows the defendant is totally innocent, but I'm going to drop it into the shredder and it'll never see the light of day. That's a Brady discovery violation. It's things, and some of your stuff doesn't apply, but I got where you were trying to go with it. But my point is that the state is obligated to turn over, frankly, very little in misdemeanor cases. In misdemeanor cases, it's really just copy the accusation, scientific reports, and the witness statement, and really that's about it. They do not have to give a copy of the video. They only have to make it available, but they went ahead and gave a copy to your attorney who then gave it to you when you fired it. And so you, I'm understanding, have everything the state has. I also am, frankly, very pleased at the speed of this case. This is the speed I dream of in cases such as this. I also know that in these cases, each side gets one free continuance. I've had that as my policy since the very first day I sat in this seat. And so I just wanted you to know that I know you had Judge Essery up here, but had you had me, the outcome would have been the same. I would have said, I'm releasing the public defender's office. You can represent yourself. And I would have granted the state's continuance. And I would have said, we're going to try this in April. Now, we're going to try this in April unless you request a continuance, which you're saying you're not. But I'm just letting you know that they've used their one continuance, which means they have to try this case in April because I would not grant them another continuance subject to some sort of providential cause. Act of God kind of moment. What I'm saying makes sense so far?
Are you saying that there is some sort of crazy evidence that was out there, some video or something that was out there that would show, innocence?
No, Dubby. No. He's not saying that. He's saying that that's what you would need to constitute a Brady violation. He couldn't have been clearer. Oh my God, go get an attorney.
Then, that would be a Brady violation?
Yes, that's the very definition of a Brady violation is the state is in possession of something that shows you are innocent and they hide it or otherwise don't disclose it. And there's some pretty famous examples of this. If you go do some Google searches, you'll see it where, so I'm saying that I haven't heard anything in this hearing today that tells me there is such a thing that has happened. I haven't heard actually any discovery violations. I've heard that they turned over their file to the public defender's office, who then turned over their file to you. I've heard that the state asked for a continuance to get ready. I haven't actually heard any violations that have occurred So I'm just acknowledging to you that I'm still waiting for someone to tell me where something went wrong.
Yeah, well, I'm just asking, like, so I mean, would that get it dismissed today if I had proof that they were hiding evidence?
Yeah, what do you got?
It would.
You have proof that they're hiding evidence?
Yeah.
Okay, you have proof that Miss Sexton over there has evidence in her possession that she is intentionally hiding from the court.
Yes, Your Honor.
To make you guilty.
Yes, Your Honor.
I don't want to see it. I want you to tell me what it is. Tell me what is in your possession that shows that Miss Sexton, an officer of this court, is intentionally violating the law by refusing to provide evidence that's exculpatory. I want you to say evidence item number 1 is.
Yes, sir. I'm just trying to get to the part where I wrote it down.
Yeah, he's got a hot bombshell, but he doesn't remember it off the top of his head.
Wasn't going to offer it today. I'm offering it to show material and
No, don't read that to me. Don't read me anything. Okay. I'm having a conversation with you, and I'm asking you a very direct question. I want you to look me in the eyes, and I want you to tell me the answer to my question.
Yes, Your Honor.
What does she have in her possession in their file that is being hidden from you that proves that you are innocent? You said you have these things, and I'm now asking you for the third time because this is like a really important moment.
Yes, Your Honor.
What is in their possession that you're saying you know about that proves that you're innocent?
Body cam video of civil rights violation, Your Honor.
So you're saying they have body cameras that they are not giving to you.
Yes, Your Honor.
And they are intentionally withholding those items.
Yes, Your Honor.
And they're lying to me and telling me that they don't have them.
When I asked my attorney if they had any more evidence.
I'm asking you,
Yes.
Are you telling me that Miss Sexton is lying to the court by saying she does not have these items, and you're saying you have proof that she has these items in her possession?
Yes, Your Honor.
What is that proof that you have that shows that these are in her possession?
The actual video, Your Honor.
Okay, well then let's back it up one step then. What is this actual video from? Who is it? Whose dashboard or body camera video is it?
It's the body cam of the arresting officers, Your Honor.
And you're saying that it's in their possession and they're hiding it?
Yes, Your Honor.
Great. You have the subpoena power of the court. They are not the only ones who would have it. You may subpoena it from the other, wherever it may be. But as of this moment, you telling me that you think something exists that they're saying they don't have is not enough for me to find any sort of discovery violations.
Your Honor, I have it with me.
So, well, have you?
Well, that's news to us because
yeah,
the only thing that I can represent to the court is that as of last night, as of 8:00 last night, I was looking through files to try to find anything other than a dash cam. And I had Georgia State Patrol who has dash cam and not body cam. Quite frankly, I'm hoping they have body cam because of the incident report, which will help me, and I don't have it. And we are going to continue to look and see if there is additional footage. If there is footage out there, I am unaware of it, but have been requesting it.
Right. Okay.
So it's not in my possession that would exonerate him that I am withholding.
And as soon as if you do become in possession of a body camera, you will turn it over to him promptly.
Absolutely.
All right. And you've given them your contact information, email address, all that kind of thing?
If you want my information, you're more than welcome to, but
give him a notepad or something. He can write all of his contact information down. All right. I'm still not hearing any sort of violation, but what I'm going to do is, all right, anything else? You said the body camera, anything else that you're saying they're hiding from you?
But Your Honor, you were saying yourself that if I had video footage that they were hiding, that it would be a Brady violation. We get it.
She's just said they're trying to find it. They're trying to get it. So her saying she's trying to find it and get it, and you saying they're hiding it, do not exist in the same world to me. Okay? You need something to show. You need the video, and you need to show me that video has been intentionally hidden from you and kept from you. I've got her saying they're diligently trying to find it. I still have 6 weeks until this trial comes up. And frankly, they only have to serve it on you 10 days before trial. So I get your indignation, but I'm not feeling it at all. I'm seeing the state trying to get discovery and serve it on you, and somehow You got a copy of a document that you haven't served on them that you're now trying to beat them over the head with, and I'm not feeling it. I'm going to tell you right now, I'm not feeling any of this. I haven't heard anything wrong at this moment to justify any of these motions.
And
So-
quite frankly, on the record, the state is asking, if he's got a copy of video footage that has something to do with this accident, I would like a copy of it because I don't currently have it.
All right. You're under no obligation to serve it. Do you want to give them a copy of it, or do you want to keep it yourself and keep it?
That's perfectly fine. Yeah, I'll give it.
Great. He has elected to engage in reciprocal discovery. Do you agree to engage in reciprocal discovery on all items that you have in your possession, or do you wish to not engage in reciprocal discovery? Just a yes or no. Do you want to give them what's in your possession, or do you want to keep it hidden in your file? It is your decision. I don't have a preference.
Is it going to be shown today, Your Honor?
No. This is preparing for your trial. This is not an evidentiary hearing. This is y'all telling me what's going on with this case so that I can line it up for a jury. That's all we're doing today. So do you want to give them copies of these things you say you have, or do you want to keep them in your file? I don't care. You just need to make a decision. What do you want to do?
I don't have it with me at the moment. I mean, I have it with me at the moment, but I don't have any way to kind of transfer it at the moment.
I'm asking you if you want to engage in reciprocal discovery. So are you agreeing to give it to them, or are you agreeing not to? Because I asked you if you're going to give it to them or not, and you're telling me you can't do it at this moment, but that's not my question. My question is, are you willing to give the state the items in your possession that you say prove Brady violations or not? Your answer is simply your decision. I don't have a preference, but I need to know your decision so that I can make my decision.
Yes, sir.
What's your answer to that question? Are you going to give them the items in your possession that you think just showed Brady discovery violations or not? Yes or no?
I mean, would it support immediate sanctions?
It's a yes or no. I've asked you a yes or no question, and you're responding with a question to me, and that is not at all what you should be doing at this moment. As you can tell, I'm already a little frustrated because we've just spent 20 minutes doing what I think has been a complete waste of time. I haven't heard a single violation. I haven't heard anything that even hints at a violation. And I'm trying to bring this to a resolution to get you to your constitutional jury trial so that you can have a jury of Spalding County people sitting over there to decide your case. Okay. And I feel like every time I get it almost there, you're shucking and jiving and I'm losing this. So I'm going to ask you the question again, and do not respond with a question to me. You are under no obligation to turn over whatever stuff you got in that pile right there to them. Do you understand that?
Yes, Your Honor.
Do you want to turn it over to them so that we can explore these Brady violations, or do you want to keep that stuff secret in your file and then just surprise them with it at trial? You have that right if you choose that.
Yes, Your Honor. I will go ahead and turn it over to him.
Great.
For the discovery.
We're done. Turn over your stuff. Ms. Sexton, if you find anything anywhere else, please make certain that you turn it over to him within at least 10 days before trial so that he has time to review it and make certain that it's ready. If it turns out by some insane set of circumstances that there is, I'm just going to say it out loud because it is my job, that Ms. Sexton is intentionally hiding evidence in her file that she is doing, I will address it at that time when we call this case for trial. But again, I haven't even heard the barest mention of it. All I've heard so far, Mr. Stringer, is that you got a copy of the video before she did. I just want you to understand what I'm seeing from this seat, that you got a copy of the video before she did, and now you're trying to use it as a hammer to beat them over and win your case. I get it. I would do the same thing if I was in your seat.
All, Your Honor.
But that is, no, I'm telling you what I'm seeing. Your opinion of my opinion is irrelevant to me. Your opinion of my opinion is irrelevant to me. I'm telling you what I'm seeing so that you understand why I'm frustrated, because this should have been a 3-second conversation. Hey, Miss Sexton, I got a copy of the dashboard of the body cam video. Would you like a copy? Hey, Miss Sexton, I got a copy of it, and I'm not giving it to you, but I'm telling you there's a copy of a body camera video, and you need to know it. Like, that's this whole issue and how it could be sorted out in 5 seconds. Okay, do you have anything else for us to discuss before we wrap this up?
Yes, Your Honor. Just one last thing.
Oh God, no.
Now just if anything, I'll leave it at that for now.
Okay, good call. All right, this hearing is adjourned. We will return to this at calendar call, which is currently scheduled for
3:31, I believe, Your Honor.
3:31. You've already signed a reset notice for that. Is that correct, Mr. Stringer?
I believe I've received one. I think I've signed it as well.
Didn't you sign a reset notice in the courtroom with Judge Essery?
I believe so.
Okay. Do you need another copy of it? You're hedging, and I'm trying to figure out why you're
I have
hedging.
it at home, Your Honor. I wasn't sure if I signed it or not, but I have it at home.
I tell you what, you're going to have to stay until we give you a copy because your answers are making me profoundly uncomfortable. So you're going to need to stay until we print a copy, and we'll give you a copy before you go. All right. I will see you back here on 3/31 at 9 a.m. sharp. Your jury trial is the entire week of May 13th at 9 a.m. each day until your case is closed. Yes.
Is it May or is it April?
I'm sorry, April. So April 13th, 2026, the week of April 13th, 2026 at 9 a.m. each day until your case is closed. Mr. Stringer, I understand that you want items that are being provided to you, and the state is under an obligation to give you certain items. But I need you to hear me say they are under no obligation to give you a copy of their video. How do I know that? Because I was a defense attorney for many years, and it used to drive me insane that other offices would say, you can come to our office and watch our video, but we're not giving you a copy of it. So I'm just telling you that I get your frustration, but this is the system and how it works. And we aren't perfect, and things aren't necessarily as they are where we want them to be, but we get it right at the end of the day. Okay. You officially have a copy of your reset notice. All right. I'm adjourning this hearing. It's 12:15. You need to make certain that you give them a copy of this item you've said that you would. I've already said to you that you're under no obligation to do so, but you've elected to do so, and that's your decision. Anything else, Mr. Stringer, before we adjourn?
That's it, Your Honor.
Anything else, Ms. Sexton, before we adjourn?
No, Your Honor.
Mr. Stringer, I will see you back here on 3/31 at 9 a.m. You can continue to represent yourself, or you can hire an attorney. I don't have any preference on that, but the public defender's office is close to you.
Yes, Your Honor.
All right. Thank you so much. You're free to go.
Thank you.
Oh my God.
Oh, I did. Yeah. I give the rest of the information.
All right, detective, this is case number 260546 FY People versus Stacy Sears. Can I get you to raise your right hand? You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, and can you state your name for the record, please?
Detective Mario Hinojosa.
Okay, and detective, did you read this complaint prior to sending this over to the court?
Yes.
And are the facts true to the best of your knowledge and belief?
Yes.
Okay, can you give me a brief recitation of the facts that would support the issuance of the arrest warrant?
Yes. Between February 24th, 2026 at 11:14 p.m. to February 25th, 2026 at 11:24 a.m., several Taylor PD dispatchers and police officers received approximately 36 911 emergency calls from a female caller who identified herself as Stacy Sears and lives at City of Taylor. Throughout the 911 phone calls, Sears was asked by officers if she had medical or police emergency and needed assistance, and she stated several times she did not have an emergency. Throughout the phone call, she was irate and upset with the officers, would be yelling at them, how she was previously treated. Throughout the phone calls, she told officers she had multiple guns and was at one point under the E-Course Road Bridge armed with loaded firearms and warned officers not to go over there. She also told the aide dispatcher if officers went to her house, she would shoot officers, and also stated on another call that she would kill officers before they would kill her. She was notified by a lieutenant and multiple officers to stop calling 911 if she did not have an emergency and to call the non-emergency number, but she continued calling the 911 emergency phone line. On February 25th at approximately 12:15 p.m., Taylor detectives conducted surveillance at City of Taylor for Miss Sears for the misuse of 911 calls and for two previous fleeing eluding investigations involving her as a suspect on February 24th. While conducting surveillance, a gray Dodge Durango fitting the description of the vehicle Sears was operating during the previous fleeing and eluding, pulled from the driveway of street. The person in the driver's seat, it was occupied by one female, fit the description of Sears, and the vehicle did not have a license plate on it. Corporal Graves, in a marked police vehicle, drove behind the Durango, activated his overhead lights, and attempted to initiate a traffic stop at Trafalgar Road and Wick Road. The Durango ran the stop sign at Trafalgar and Wick Road and continued westbound on Wick. The Durango accelerated at a high rate of speed through multiple streets, trying to evade the officer and not stopping at stop signs in the residential neighborhood. The Durango continued into Hague and westbound all the way to Oak Street and southbound Birch as Corporal Graves continued the pursuit. The Durango was stopped in the middle of the road and was blocked in the middle of the road by two parked cars, with a civilian car parked in the middle of the road blocking the Durango. Corporal Graves exited his patrol vehicle in a fully marked uniform, approached the driver's side of the vehicle, and ordered the female to exit the vehicle several times. Detectives Collop and Detective Giacomo were also there giving verbal orders. The female fit the description, looked wearing with light brown hair, glasses, approximately 50 years old, and fitting the description of Sears. The civilian vehicle that was blocking the roadway moved out of the way. Sears honked the horn and sped off away from officers. Corporal Johnson observed the Durango heading eastbound on Wick past Pardee at speeds approximately of 50 plus miles per hour in a 35 zone. And the vehicle kept pursuing in that direction down Wick Road. And then the pursuit was terminated. Detectives were able to locate the vehicle, continued surveillance all the way to the Huron Metro Park, where she continued to pursue. There was another pursuit involving Metro Park Police and Huron Township Police, where the vehicle was eventually came to an end. They were able to get Sears in custody. Detectives executed a search warrant on the Dodge Durango, which came back unregistered per lien. We located 9 firearms in her vehicle, including rifles, a shotgun, and several handguns and gun cases in the trunk of the vehicle. One of the handguns, a silver North American Arms Guardian .380 caliber pistol, had 1 live round chambered inside of the firearm. I confirmed via lien that Sears does not have a valid CPL.
So the calls, the 36 calls were from 11:14 PM to 11:24 the following day. It's like roughly a 12-hour span.
Yes, a majority of them were within a 5-hour span between 11 to around 3:30 a.m.
Okay, and Detective, did you sign this complaint prior to sending it over to the court?
Yes.
Okay, let the record reflect that I find probable cause to believe that the accused committed the alleged offense. I'll therefore issue the arrest warrant. Detective, I understand she's in custody. Do you have a position on bond?
Yes, I want, if I could request a high cash bond. I believe she's a flight risk. She is known to travel out of state quite frequently to Kentucky. GPS tether, and I think she's a danger to the public. Running when she's pursuing after with Huron Township, she's going over backyards, hitting fences, disregard to everybody around her. She fled from 4 different police departments within the last several days as well.
And the after we terminated, that's when Huron Township picked her up for any charges that they have, correct?
Yeah, Huron Township, Metro Park Police Department, and Huron Township as well. And they're doing a separate thing for that.
Okay. All right. Thank you, Detective.
Have a good day.
Thank you too.
All right, this is case 260546 FY, People versus Stacy Sears. Can I get your appearance?
Good afternoon, Todd Barrett, on behalf of Mr. Sears, limited appearance for purposes of arraignment today. We will waive the formal reading of the complaint and stand mute.
All right, Ms. Sears, state your first and last name for me.
Stacy Sears.
All right, Ms. Sears, you have the right to remain silent. Anything you say orally or in writing can and will be used against you. You have the right to have an attorney present during any future questioning and any future court hearings. If you cannot afford one will be appointed to represent you. Ma'am, you're going to have 2 dates within the next 21 days. The first will be your probable cause conference. The date for that is going to be March 9th. You can appear for that via Zoom. Your second court date is going to be March 16th. That's going to be your preliminary examination. At that hearing, the prosecutor must show that a crime was committed and that probable cause exists to charge you with that crime. You must appear in person for that hearing. I do have a request for a court-appointed attorney in front of me, so I'm going to sign that so you have counsel with you at your following court dates. Oh, you know what? This just go in that file. As to bond counsel, I did swear this in. I'm familiar with the allegations. Please don't ask me for a personal bond, but you can allocate as to bond.
Understood. I do understand the seriousness of the charges. I expressed those with Ms. Sears and she understands. I'm not aware of any other watch warrants or holds. No history, certainly nothing of this nature in her past. She does reside at the address that was indicated on Oak Street. She's provided a good address as well as phone number. Not employed. She's receiving disability in Medicare currently. And also has a 27-year-old daughter. She has guardianship over due to a disability.
Thank you. So I'm familiar with the allegations. I just swore this complaint in with the detective over at TPD. She does have a hold out of St. Clair Shores, so I will just note that for the record. But the allegations here are more imperative to this court. I understand she doesn't have a significant criminal history, but she went from 0 to having a felony charge where she's going to be presumably downtown in just a few weeks, depending on how her later court dates go. The allegations here and per statute, this is what this court has to take into account, are that she not only fled from the police, which is what the black and white complaint would lend itself to, but that she was making 36 phone calls within roughly a 12-hour span, but more so about a 5-hour span, 36 calls to the Taylor Police Department, threatening to shoot them, to kill them if anybody were to come to her house. She was more than willing to kill the Taylor police officers if they were to respond. The pursuit, which lends itself to that fleeing charge, happened, and then there were several, I think it was 9 firearms, there was cases, there was ammo, knives, all of these things were found in her vehicle, which was a search warrant was executed and they found that. What I think was very interesting as well is that in one of her complaints, she indicated that she was on Ecorse Road. And again, counsel, I understand that's just an allegation, but that she was on Ecorse Road. She had a shotgun, she had a scope, and lo and behold, one of the things that were recovered in her vehicle was a scope, and among all of the other weapons was that shotgun. So I don't think these were mere threats. I think she was very much able to carry out those threats. I think if the Taylor Police Department and their surrounding cities hadn't been as professional as they were, we would be having a different conversation, very similar to those in the surrounding states that we've been having. But thankfully, it didn't escalate to that. So she's absolutely a danger to the community. Fleeing, this is a fleeing third. It's obviously evidence of flight. She has significant contacts out of state. There was a statement that she has been to Kentucky several times just in the last 2 weeks itself. I believe she's a flight risk. Her bond is going to be $100,000 cash surety. She's going to have a GPS tether and house arrest. She's not working, so there shouldn't be a problem, but she's a significant danger to the community. I don't know what she's going to do if she gets out and she has access to all these guns. It's my job to make sure the citizens of this city and obviously, the surrounding areas that she's availing herself to, but specifically the citizens of Taylor, that they have a sense of security, and Ms. Sears clearly can take that away. So $100,000 cash surety. Ma'am, your bond conditions are as follows. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. If you change your address or your phone number, you need to immediately contact the court. Ma'am, you cannot contact the Taylor Police Department unless it is in case of an emergency. And that means a real emergency, direct or indirectly. You can't have access to firearms or other dangerous weapons. You can't consume alcohol or illegal drugs. You'll be subject to drug and alcohol testing at your expense on demand. And I'm going to require that she participate in a mental health assessment as part of her pretrial release, if and when she's released. Counsel, do you want a DSU?
I think that would be appropriate, yes.
Does this file need to be marked medical in any way?
I am not aware of that, other than she did indicate the disability was due to severe anxiety. I'm not aware of any physical ailment.
Okay. All right, then we're all set. Thank you.
That just looks like, how many more do we have? Oh, like 20. Maybe not that many, but like 8. Oh, 8. This is docket, are you ready? And go ahead. This is docket 24769 FH, People of the State of Michigan versus Tyler Wallace. Counsel, your appearance for the record.
Good afternoon, Your Honor. AP Bart Buxton on behalf of the people of the state of Michigan.
Thank you, Stephen Graham, on behalf of probation.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Wallace, who's standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
Yes.
And does that interfere with your ability to understand the court or your attorney?
No, not today.
And you're feeling okay today?
Yes.
All right. Any sign of fever, COVID, or other illness?
No.
Have you had an opportunity to speak with Mr. Goodrich?
Yes.
Mr. Goodrich, do you believe he's oriented to date, time, and place, and does understand what's occurring today?
Yes, Your Honor.
Thank you. Sir, you pled no contest to count 1, weapons, firearms, possession by felon with habitual. Second, it was punishable by 7 years. I have a probation violation. Counsel, have you reviewed that with your client?
Yes, I have, Your Honor.
All right. Are there any amendments?
No, Your Honor.
Thank you. Sir, I have his probation violation or request for a bench warrant that the court signed. And I signed that on January 22nd. It alleges the following. Count 1, on or about January 15, 2026, or any date thereafter, defendant failed to report to probation. Count 2, on or about January 6, 2026, defendant violated a personal protection order. Are there charges stemming from that?
I believe there's I
have court on the 6th.
A person protection order hearing downstairs.
All right, so that one's going to be held in abeyance. All right, so the only one we can deal with today is January 15, 2026, failure to report to probation, and anytime thereafter.
Your Honor, he intends to plead guilty to that.
Is that correct, sir?
Yes.
All right, you understand the violation?
I do.
All right, and you're pleading of your own free will?
Yes.
After you discussed everything with your attorney?
Yes.
And you've been satisfied with the representation, Mr. Goodrich? Have you been satisfied?
Yes. Sorry, I thought you were asking him a question.
As to count 1, on or about January 15th, 2026, or any day thereafter, failure to report to probation, how do you plead?
Guilty.
Did anyone force, threaten, or coerce you to plead?
No.
Anyone promise you anything that caused you to plead?
No.
you understood you needed to show up each and every time probation wanted you to, and if something came up, I believe I advised you, and if not, they probably advised you that you just need to reschedule, let them know where you're at, and you failed to do that, so we had
I
eventually.
didn't have a phone at the time. I apologize.
Yes or no?
Yes, I understand.
All right. I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made. He is now in contempt of court. Count one will enter. Let me just turn to you, sir. You started to say you didn't have a phone at the time?
Yeah.
Well, you
pretty
got-
much, I was going through a lot of mental health stuff, so I just kind of gave up really. So
Were you not on your meds?
no,
But you're on your meds now.
I haven't taken them since I've been here, but yes, I'm,
Why aren't you taking them?
because the jail doesn't have my meds. My meds are pretty much at home.
Where are your meds?
At home.
Is there someone there that can bring them to you?
No. My grandpa, they're pretty much in my grandpa's house. So that's where I've been staying at. And he's 83 years old, so he doesn't drive anymore.
Okay. All right. What's the recommendation probation?
Thank you, Your Honor. The recommendation for probation is going to be adopting the 365 days that were held in advance with credit for 7 days served. It should also be noted that his discharge date for this was actually February 13th of 2026, Your Honor.
I did want to ask.
Wait a minute. February 13th of 2026?
Yes, Your Honor.
Well, then we're not.
Well, I believe the warrant went out in January. It's
Oh.
Yeah, this is the warrant is from
Okay.
January.
Oh, okay. I got you. Okay. All right. Well, that's when I signed it. So, all right. How many days in jail does he have?
As of right now, Your Honor, he has 7 days for this current arrest.
Plus what?
Nothing.
You didn't have any on the original?
No, I served time in Boone County for my other stuff over there.
yeah, he
How much
was,
time did you serve there?
7 months, 6 months. And I'd really like to continue doing probation so I can do better because I have just a lot going on.
Yeah, we just lose jurisdiction. I could extend probation, but sir, do you need help? What's the story with you? Are you working with community mental health?
Yes, a little bit. But then, I mean, with my relationship issues and everything else, where I just kind of just give up.
What do you mean relationship issues?
With kind of how there's the PPOs with her mom, and I'm dating the daughter I was, but there was those issues, and then just other issues like my mom's dying and my little brother's in foster care, so there's have a lot going on right now.
Okay, let's take them one at a time. You got a girlfriend, but you don't like the mother.
The mother doesn't like me,
Oh, okay,
but she was my girlfriend. She broke up with me since then, but
great. Is she out of your life?
that's why I'm trying to actually get my life back on track.
Okay, here's the thing. When you date,
I like her. I like her. That was my thought too, but she said it out loud. Great. This sounds like a mess. Breaking up is the best thing that we could have.
someone, and especially if you marry them, you get the whole kit and caboodle. It doesn't matter who you like and who you don't. They're all in your life. So if someone doesn't like you, just say goodbye to the other person. The world is filled with people you can date.
I understand that.
Okay. And you got to stay in your medicine so that you're thinking right and you can
And they're all awful. Every last one of them.
make those decisions,
A
right?
couple weeks ago, I actually did go to the crisis center, and that's when I got put back on my meds.
So you're making better choices.
And
Okay. Are you working?
somewhat, but
Well, what's
kind of-
somewhat? Either
it was-
just like, you know.
it was under the table. It wasn't.
No, we don't say that here because that's a federal and state crime. So you're getting paid as an independent contractor. I hope you're going to pay taxes on that. So you do work. So what do you do, sir?
I was painting.
Painting, great. Okay, you got some skills. Okay. Has he completed anything on probation?
Your Honor, he has not. I've received an email from MMRS, which he was referred to complete CBT. They indicated that he completed his intake assessment on 12/31/2025 and enrolled in a 4 p.m. CBT group with a start date of 1/6/2026. However, has not attended any group session. And they were informed on 1/31/2026 by Agent Bean, who is his primary agent, that he had absconded.
Okay. So let me just talk to you about, you were in, what'd you say, Eaton County for 8 months? Is that a yes?
Yes.
7, 8 months?
Yes.
Okay. So I'm familiar with Eaton County. I used to practice in all these counties. So Eaton County has a whole bunch of really good programs there. Did you participate and complete anything?
No, there they weren't. My supervision was here, so I didn't know.
I mean, while you were in custody.
While I was in custody, no, I don't believe I did. I was doing the GD program and stuff like that or whatever, like classes like that, but other than that, no, I wasn't.
Did you get that completed in the Eaton County Jail or?
No, pretty much they didn't do it there. They said when I got out, I was supposed to do it, but I got out the same month that they were taking that class and stuff, so I never got to, so I have to go back and do so.
Okay, so let me understand the rest of the story. Your mother is ill?
Yeah, she has congestive heart failure and she's in a wheelchair, kind of like a rehab facility right now, so
How old is she?
like 50, 51.
Wow, that's horrible. And what else is going on?
My 9-year-old brother's in foster care and has been for almost a year. And pretty much it's to the point where they're about to like, we have to get him back now or he's gonna be in the system.
Well, sir, how are you going to do that when you're in jail and when you've got all this criminal stuff going on?
I didn't plan to go to jail. My grandpa was gonna help me pretty much get back on my feet. And that was gonna be the place I was gonna try and get my little brother to, because they were gonna give me the opportunity to have custody of him, so.
So you're going to live with your grandfather and the two of you are going to raise your little brother?
Well, I was going to, and to help take care of my grandpa also.
Yeah? What other family you got?
Just him and my mom, pretty much, my stepdad. He's not in the picture. My real father passed away.
Okay. So taking care of a 9-year-old is a lot of work.
Yeah.
You think you're going to be able to stay in your medicine and do all that?
Yeah, I have a 10-year-old and a 3-year-old, or a 10-year-old and a 6-year-old myself, so.
So are you seeing them?
I haven't seen either of them in a couple months, no.
Why?
Kind of issues with the mom and girlfriend.
Oh, sweet Jesus. What?
Don't like you is the grandmother of your children?
One of them, yeah. So I kind of just gave up and just said screw everything because I kind of just, everything just went bad.
Do you have custody orders with the family court?
No, it's something I need to do, but I need to get everything in order with this. That way I can actually go do that.
Have you ever received an award? Well, you just got one today. I'm giving you the award for the most excuses of the day.
No, I'm not trying to make excuses. It's
We
just,
are, sir. Let me just tell you a couple of things. You have a constitution.
I have to admit, I was wondering where she was going with that.
Why don't you look at me? You have a constitution protected right to raise your children. You're the one that needs to step up to the plate, go to the family division downstairs and say, I want to raise my children. Those children are entitled to child support. It's a right and entitlement of the child and an obligation of the parents.
I'm trying to do
To
everything I
pay
can.
child support. Interrupt me and we'll continue this in 93 days. You didn't try nothing because I don't have any papers here saying there's any case open there where you're filing for custody and paying support. And you're getting paid unlawfully. You better get a 1099, claim whatever wages, and show in front of the court that you are capable of having money, earning money, raising your brother and your children. It doesn't even begin to scratch the surface of what you have in front of me with all these guns. Do you think that you're going to get custody of children? The number one killer of children is guns. And now I know you only pled to one, but I got 18 counts of felony firearm and various gun charges. 18 counts with a visual second. You are lucky you're not in prison.
I understand.
At what point are you going to get your life in line?
I'm hoping to now.
Uh,
I realize that I'm too old to pretty much be doing this and
She's fun.
back and forth. I realized a lot of it has been relationship issues. And like you just said, there's lots of people out there, and I just now realized that at damn near 30 years old that there's other people out there, and I don't need to just be stuck on one. So
Exactly. There are people that would make you happy instead of miserable and in the jumpsuit. But you got choices to make, sir. So here's the thing. If you want to see your children, you need to file with a friend of the court and with the family court judge and get some joint custody, parenting time, whatever it is. But you need to be law abiding, and you need to work, and you need to be appropriate, and you need to take some parenting classes, and you need to petition the probate court for your brother or child protective services or whatever,
I think we all know he doesn't want to do that and won't do that.
and do all that.
CPS is, that's what they were talking about, is giving me custody pretty much, but they needed action.
Yeah, they're gonna,
See that I could take care of them, so.
yeah, they do a lot of talking. They're gonna do a lot of walking the other way as soon as you don't show up. This state is harsh on criminal termination. I did 20 years of that kind of work as a lawyer. I represented people like you. I represented kids. I represented grandparents. It didn't matter. You got to be good every step of the way because the state does not care. What they want is a fit parent.
2024, they gave me temporary custody of them, but in the end of 2024, I kind of got shot in the head. So like, that's why I've been having a lot of mental issues too, or whatever. So like, I'm trying to get everything taken care of.
Yeah. So in 2023, we had these charges in your file. And you kind of didn't get the message. So playing with guns and people with guns, you get shot in the head.
I don't like guns pretty much. These are all the ex-workers guns.
Well, your record says otherwise. So let me just see.
We're fine. I'm with everything.
How long did I have him on probation?
Just 6 months, John. So we would ask the court to consider just extending that.
Allowed you to leave the state to drive, to be a truck driver. Did you lie to me? Were you driving a truck?
That was at one point, but I didn't do so because you said you needed an actual schedule, and that's what my probation officer was going on with. He needed an actual schedule of when I would be in town and when I wouldn't, and it would change. So I never actually.
It changes every day. You just fax the schedule. Do you know how many people are? We have lots of truck drivers. It's a good job.
So that's why I didn't pursue that, and that's why I went with pain.
That's another shitty excuse. Again, number one excuse maker of the day. Look it, sir. You take your schedule and you have your employer fax it, or you take a screenshot of it and you send it over to your probation agent. Not hard. We just need to know where you are because we have compacts and the other states will yell at us and they'll say no more. And there's all sorts of other reasons that government does that I'm not in charge of the world. So I can't control that. I can control what you do and how you comply. Take a screenshot, give it. They say, okay, we're good. We just need to keep track of you.
Good. I didn't understand that at the time, I guess. I'm sorry.
If you show up to probation, they explain it to you. And if they don't understand, they can call me 24/7. And guess what? I pick up the phone.
Okay.
So here's what we're doing. We're doing 5 years probation. He's going to comply with family court orders, personal protection orders, child protective services orders. He's going to remain residing with his father. He's going to take parenting classes because if he's going to get custody, he's going to need them. He is going to follow everything on CPS, whatever they have him do, become orders of this court. He doesn't have to do duplicate. And we can amend it as reasonable so we don't overwhelm him. But sir, it appears you need some help being successful in putting your family together. Well, that's what probation is for. Now, if you decide that you're tired of all this, you just let me know. I can send you to jail or prison. And technically, it's only 3 years probation I can do, I think, right?
That's correct.
All right, so do the 3, but 5's not out of the question because if you violate again, I may make it 5 and I may send you to prison. Got it?
Got it.
But I said 5 so you know how serious I am. Get serious about your family and your kids and straightening up.
In December, I did text my probation officer and I called him a couple of times because I did ask for help because I was wanting to get back on track and do what I needed to do. So at least for the last 2 months, I have been wanting to do better. So thank you for the chance.
A lot of people want, I deal in evidence. Show me the evidence, sir. I'll be jumping for joy when I sign a successful release from probation. You got 7 days of credit for 7 days, but you get 365 credit for 7. The balance is held. Make no mistake, I will use any or all of that as needed. Do you understand, sir?
Yes, I understand. And for my probation in Eaton County, how is that going to go about? Still just the same?
We can transfer it, but you first have to, is it transferred?
If the supervision was here, but I don't understand how that's going.
Well, you first have to show up and tell us that's a problem. Is he living in Eaton County?
He is currently living in Ingham County, to my knowledge. Speaking with his agents over there, he may have, they were speaking about possibly having TI or a transfer back to Eaton County for supervision. His case is here and he has a separate case in Eaton County.
Well,
Currently
is
living in
Eaton County, are you supervising for Eaton too?
No, Your Honor. We're only supervising him for, oh yes, I apologize. Yes, we're supervising him for both Ingham and Eaton.
So you're living in Ingham, why do you want to go to Eaton?
I was just asking how that's going about. Is it still going to be continuing the same supervision here for both?
Yes,
Okay.
yes. Don't mess up, sir.
Your Honor, one thing I did want to clarify, just for people taking notes, I believe you said you were ordered him to reside with his father. And I
I'm
think you
sorry,
meant his
his grandfather. I did mean his grandfather, yes. He can't reside with his dad. His dad is no longer with us. He's with God, so.
And also, so the court in probation are aware he does have a hold to Eaton County, and we'll have to address that first before getting back started on it.
That's kind of why I asked how that's going about, if they're going to be two separate.
She can't tell Eaton County what to
I
do.
can't tell them what to do. I don't know. I just know we're going to try to help you out.
Thank you.
Hopefully they'll listen to what I did and give you another chance. You got a lot of things going on, sir, but you know what? Probation is your friend. They're not your enemy. This is to set you up for success. Jail and prison is the downside. Probation's a good thing. Show up, ask for help, show us what you've done. Continue your education, get your kids and your family and your life in order. Before you know it, you're going to be 90 and reflect on what did I do with my life.
I don't want that.
When you think about how you're going to explain that to your dad, to God, I don't know. That's not going to be a fun conversation, is it? So let's have a conversation you can be proud of. It's okay to make mistakes. It's what you do with them. You got to learn from them. So here's your blue light special and your award for today.
Thank you.
Get on it, sir. That's all for the record.
Back then to the 8:30 calendar, we haven't addressed Robert Powers.
No representation, Your Honor.
He was summoned for arraignment 17335. All right, we had previously reset this to attempt new notice to a DOL address. That notice was returned, so we have no other way to get a hold of them. Okay, so the charge is protection order violation. There has been no prior finding of probable cause, so Ms. Pritikin.
Just a second. Sure.
All right, do you swear the testimony that you give in these matters this morning will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay.
On November 20th, 2025, Thurston County Sheriff's Deputy was dispatched to a protection order service at Lane Southeastern Yelm. The reporting party told dispatch she had a temporary domestic protection order to be served on her partner, the defendant, Mr. Powers. Law enforcement arrived, received the service packet, contained a temporary order of protection, order of surrender, etc. And the temporary order listed that the defendant should vacate the shared residence. She had coordinated for one of his friends to pick him up after the order was served. He was going to stay at the end of the driveway until he was signaled to approach. She told law enforcement she was concerned that he would be combative or uncooperative with the order service. He apparently lived downstairs in the home, accessed through a different set of doors. So law enforcement went downstairs. They attempted to call him, phone went right to voicemail. Because of some suicidal messaging that they saw on the victim's phone from the defendant, they developed a plan to enter the residence. They opened the door, received no response. As they entered, they continued to announce their presence as law enforcement. He was seen in the bedroom, laying face down on the bed. He was breathing. They informed the defendant it was the police, sheriff's office. He roused slightly and then got quite a bit belligerent and was swearing at law enforcement and did not comply with leaving. He shouted, "Serve the blanking papers, I'm going back to sleep." Law enforcement informed him that the papers had been served and he needed to leave, and he did not leave. He was repeatedly asked to leave. and warned that he would be arrested if he didn't leave, and he said that he was going back to sleep. So he was placed under arrest.
All right. Sounds like there's probable cause for violation of the order. Happened to him, though.
I don't know. That's why,
Trying to see if I can sort out
as I was reading that, sort of trying to figure out
where he went. Maybe he had an extraordinary medical placement. That's why he wasn't heard. I don't know. All right. Well, I'm going to, like I said, find probable cause. Yes. Issue a warrant, $10,000. Then we'll go to the 9:30 calendar and
Arbor Meadows versus Akio Fujimaki.
Good afternoon, Your Honor. Gabriel ACP 79685 for the plaintiff, Arbor Meadows.
Did you hear us talking about you?
Yes, Your Honor, and I do appreciate you allowing me to appear via phone.
You're more than welcome. All right, Mr. Stringer.
Yes, Your Honor. Thomas Stringer appearing on behalf of Akio Fujimaki.
All right. I have a dismissal.
So, Your Honor, if you could allow me this time to address Brother Counsel, I had a family emergency, and I do apologize. I did not get to reach out to you and let you know that we were dismissing this case. And we will not be bringing up the other cases.
You have any objection to that?
Well, I have no objection to it being dismissed. My client did want me to ask for fees. You reserved them. I've had to come back again. When I look at I looked at my time after today, I'll have between $1,200 and $1,500 into this. It's unfortunate that my client gets charged for that.
Yeah, I will state that.
Anything to say to that?
Yes, Your Honor. I will state that this could have been resolved if he had just paid the court cost with notice. And my client was willing to do that and waive the late fee. I was willing to be very amenable, and at this point, decided to just do a courtesy fee waiver for the court cost.
Right.
And I do not believe that fees should be attributed to my client, as my client's just trying to assert their rights as a property owner and keep the place where he calls home beautiful.
Yeah, but remind me, were the court fees due?
There were court fees, but the issue was Your Honor did not specifically award them in the last case. That's what it was.
Right, but that's part of the problem. And Ms. Lacy, I appreciate that you at Emergency Counsel has been out here twice, and I was extremely skeptical of the argument that was being made at the last hearing, because everything was settled. And quite frankly, I don't know that Arbor Meadows should have been coming after him for something that wasn't contained in the written agreement or judgment between the parties. And that was part of my problem. And now we are back here again. And
And I appreciate counsel having some family issue, but somebody from the firm could have sent me a dismissal. At least I wouldn't have had to come out here today. And that's what's inherently wrong about this. And I'm not blaming counsel, but obviously she works for a firm who decided to file this. And really, there was no merit to filing this. And saying that Mr. Fujimaki could have paid the fees, well, he wasn't ordered to pay the fees, and we never agreed to pay the fees. So this is just wrong. I'll leave this up to the court.
And Ms. Lacy, I get the family emergency. I get all of that, and you kept the court apprised that you weren't going to be able to be here today. I wasn't sure what was happening on the case. So that I think all of us that have been in practice realize stuff happens, right? Okay, so I get that. I appreciate, though, what Mr. Stringer is saying, that somebody could have sent that. I am also, how do I want to say this? I'll put it this way. Sometimes people are sent in to give arguments that may themselves not have a whole lot of merit, and they have to just go about doing their job. And I can appreciate that. And I don't fault attorneys when they're placed in that position. I may be wrong, but I think, Ms. Lacy, you always give very good, cogent arguments grounded legally before this court. I felt, well, I'm just going to say it, and I don't know if I'm right, but I think that if it were up to you, we wouldn't have been here last time arguing. I think somebody has put you in that position, and unfairly so. I say what I think. I think you were put in that position unfairly. I don't think you would have given me that argument, because that's not what you do. But Mr. Stringer and his client should also not be. So I'm not going to award the $1,500 or whatever it would be, the $1,520. I will award $500 in attorney fees that will need to be paid by, I'm going to say is that it needs to be paid by the plaintiff to the defendant's attorney.
We have a time frame, Your Honor? 2 weeks, a month?
Yeah.
Whatever the
pay it by March 16th, 2026. All right.
And I just want to put something on the record that I've had my assistant check every day for the last few days to see if we were receiving anything.
Right.
Because originally she was going to, and I'm not blaming her, going to file a brief or file an amendment to request an amendment. So there was just nothing ever, and the dismissal could have come. I mean, from somebody.
And I'll say this, and I'm not here to defend Miss Lacy. I'll just say this. Hey, if she could have, she would have. I have no doubt in my mind. And I think that there may have been outside things hampering her. So I don't hold her responsible. That's why I phrased it the way that I do. I don't think that comes, I don't know whose pocket it comes out of. I'll make this clear in my mind. It should not come out of Miss Lacy's pocket. Whoever did what they did, that's who should be paying. I don't think she would have done this. She's never done that in the years that she's been practicing.
I fully accept that. I have no ill will at all.
I know you don't. So, and it's a good thing that this is the attorney on the other side, because this could have gotten real ugly. So, all right.
Probably true.
Yes. Thank you.
Thank you.
And Ms. Lacy, I'll say this. Mr. Stringer doesn't come out here that often. He used to come see me all the time. Now it's every once in a while, here or there. So the very fact that it didn't get to him and I got to see him again, I'm okay with it.
Mr. Stringer, my sincerest apologies, and I do thank you, Your Honor.
Well, and I appreciate that. And again, there's no ill will whatsoever. I think you're a fine attorney. And just things happen.
Things happen. All right. Thank you.
Thank you.
$600. No, $600 from our meadows to requested me is sharing gone. $600 is.
That's in the other case.
What's going on?
Oh, yeah, no. This case is being dismissed.
This case is being dismissed.
That's what he's asking about, the $600 that they requested.
Yeah.
Absolutely.
All right. Thank you.
Thank you, Aaron.
Field Properties versus Matata Patrick.
Oh, well, isn't that sweet? That was awkward. Judge Simpson split the baby there. What are you gonna do? What are you gonna do? All right, good times. That was fun. Lots of good clips there. Thank you, Zach. He put all that. I'll tell you what happened. Zach is awesome, and he puts together a bunch of stuff, and it's like the weekend. And then yesterday, I got that Laura hearing. So then that was long. So I did that for yesterday, and then I had all this stuff. So we had a big, long, rambling, fun Sunday stream. Good times. Thank y'all for coming out. I appreciate it. And thanks to Zach at LawNerdsUnite, as usual.